Good afternoon, everybody. It's a privilege to have you with us. My name is Bryan Starrett. Along with my colleague and partner, Jessi Thaller-Moran, we're going to talk with you about what might sound like a highly intriguing and perhaps timely topic: when employees go rogue, which obviously can mean a lot of different things. And it sort of depends on in what way they go rogue about how we might think about what the responses and actions and decisions you're going to have to make. So today we're going to talk about how to navigate the legal issues and manage the fallout that comes with whatever the rogue action is. And we're going to do that not just in a sort of general sense of, some general guardrails or rules of the road or variables to consider. We're actually going to use some examples, some real examples. I wouldn't say ripped from the headlines, but I think you'll find that some of what we talk about today is not too different from things you've read about, heard about, or can sort of sympathize with. If we can go to the next slide, please. So like I said, it's today, it's myself, Bryan Starrett, and Jessi Thaller-Moran joining you. I'm resident with Brooks Pierce here as a partner in the Greensboro office. Jessi is a labor and employment partner in our Raleigh office, and we've had the privilege to work both separately and together on lots of, let's say, interesting matters in the vein of what we're going to be talking about today. I often tell people that if you want to understand sort of the most unique and crazy things that humans might do, both in the workplace and beyond, there's no better area of law to practice in than employment law, because we don't get the calls when people are behaving. We get the calls when people are misbehaving. And so that's what we're going to talk about a lot today. And so really what we're going to try to do today is give you not only those, as I say, rules of the road or thoughts on how to navigate from beginning to end some sort of unexpected situation. We're going to talk about that both specifically with some examples and walk through sort of the steps that we have gone and would advise to go through when you're addressing whatever the situation happens to be. And we're going to do that by way of first starting with the threshold issue of, okay, something's happened. Somebody's done something crazy or inappropriate or potentially unlawful or made allegations of illegal activity, whatever it is. You start with sort of the triage and assessment stage. And we're going to start there and talk through about the steps and decisions and variables you might want to consider at that stage. And then we're going to talk about how to develop an action plan. And we call it a bespoke action plan because every situation is different. And we're going to give you at least 4 sort of unique ones here as we spend time together today and show you how just those different sort of rogue activities or actions are going to dictate different thoughts and action plans. We're also, of course, going to make sure we talk about the legal landscape that applies to the decision-making you have to do both at the front end of your process of dealing with whatever's happened and throughout. Because of course, I don't at all consider myself a highly effective person, as Stephen Covey defines it. But in the seven habits of highly effective people, the one that I always try to keep in mind in this context is beginning with the end in mind. And so we try to think very hard and carefully on the front end about what are all the variables that we should be considering and the legal risks and concerns that we should be mindful of, so we can develop an action plan that is mindful of all that. And then finally, we'll talk about the resolution stage and actions, both to close out the work that you've done and to communicate what you've done. How do you communicate it? To whom might you communicate? And you're going to hear us lawyers say things like, it depends, because it does. Every situation is different, but we're going to try to give you some examples and some variables to consider as it relates to all those. Just as I know you can expect, particularly for those of us who have joined us before, while we're going to talk through a lot of examples here, nothing that we talk about today should be construed as specific legal advice, and certainly shouldn't be construed as a substitute for getting legal counsel when you need it. I think you'll find in this topic in particular that every situation is different. And so we're going to try to put some arrows in your quiver of important things to think about. And I just want you to know that while they're helpful and important, what we'll talk about today, they may or may not be bespoke for your situation. But as we go through today, we hope that you will ask questions of Jessi and of me via the chat. We've got the chat open. We'll be looking at it and monitoring it. We can certainly address questions at the end, but if you have them in real time, please don't hesitate. We'll do our best to make sure we're mindful of those. Okay, so let's start with whatever the thing is. Something happens, and who knows what that something is, but we're going to try to, this is sort of a thought experiment and exercise we're going to go through today. And we're going to use 4 different examples that I think it's fair, Jessi, for me to say that the names have been changed here to protect the implicated, but everything we talk about as an example today, we've sort of ripped from our own experience or from headlines or some combination of the two. So here's 4 different types of, rogue actions, for lack of a better term, or things that have happened that require a response and a plan. So the first one is we've got, Miss Scarlett complains on social media about bad behavior by her supervisor, Colonel Mustard, and the post in which she makes that complaint mentions your company by name. So that's 1. 2, we've got Mr. Green complaining internally, perhaps to coworkers, perhaps to the supervisor, perhaps to HR, that Mr. Green and others in similar positions to him aren't being paid fairly. What are we going to do with that? Next, we've got Professor Plum. Professor Plum's putting social media posts out there that are aggressive and political and derogatory language about a certain particular group of people, perhaps a protected class of people, as that legal term is used. What are we going to do about that? And then finally, we've got Mr. Body. Mr. Body has accused members of the company's senior leadership team of discriminatory treatment and behavior regarding multiple employees. This is sort of a allegation about folks sitting at the top of the organization. So as I hope you see just right out of the gate, each of these is different, but each sort of jumps off the page as having, number one, the need for some sort of thoughtful response and some level of risk that's just sort of been presented to you or to the company. And so now we've got to figure out, well, what does this mean and what do we do with that? So here's how we're going to do that. Again, just as a reminder, the thing happens, and we just talked about 4 things that might happen. We're gonna work through the legal landscape. What are all the legal issues or laws that might be implicated? And I don't want to suggest to you that what we talk about today is an exhaustive list of what those might be, but we have tried to be thoughtful about sharing with you what we think the most common or most likely implicated legal issues and laws are, and not only that, but also what sort of the latest developments and sort of guidance on some of those laws has been. We've had in several fronts that Jessi will talk about some very important and frankly novel developments on some of these areas of law. We'll talk about how to do a fact-finding / investigation. That is really the begin with the end in mind part more than anything. What are we going to do with these 4 situations? What are we going to do about Ms. Scarlett and Professor Plum and Colonel Mustard and Mr. Green? And are those processes going to look the same? Are they going to look different? And why? Then we'll talk about communication strategy. Who are we talking to about this? Who are we making sure we don't talk to? How are we cabining off information in an effective way to make sure we get to the bottom of whatever's happened without, while also honoring our own policies about confidentiality and being mindful of the sensitivity of information, and frankly recognizing that until proven, allegations are just allegations, and we don't want to do more than is necessary to get to the bottom of that that might cause some indirect harm to somebody. And then finally, we'll get to the end of the process. We'll talk about how to sort of synthesize and think through what you found and how to think through what you're going to do about it. Okay, so the thing happens, whatever the thing is. What do we do next? We're at the very beginning of this. We're in our reaction mode. This is our initial assessment stage, and the first step is, candidly, don't do anything immediately. I can't tell you, just take a breath, take a beat. Many times we have seen situations in which a workplace issue arises, and out of frustration or reaction or emotion or whatever, perhaps an HR person or a supervisor or even a senior leader fires off an email about sort of that comments on the situation in a way that, let's just say if that email were to appear in a subsequent piece of litigation or on the desk of a government investigator, would be very unproductive. And so the first step really is to just take a breath and recognize that whatever you do next, you should be thinking through the lens of what evidence am I creating? What steps that I take here might both improve or move the ball forward or cause harm to the situation that I've just been presented. No one wants to have these problems fall in their lap, but to react to them in an emotional way without being thoughtful might cause you to create an unnecessary stumble out of the gate.
Bryan, just to jump in on that really quickly, for Bryan and I, part of our job is reviewing text messages and emails that people never thought anyone else would ever see. And I can tell you there's a lot of them. And whether you communicate primarily by Slack in your workplace, or you text, or you email, those things last for a long time and often go beyond the intended audience. And so that's what we say when we mean be mindful of creating evidence. Something that today feels like a very innocuous message could be evidence in front of a government agency or a court down the road. So that's why we recommend pausing before you even fire off that venting email. Just take a moment to gather yourself and figure out the next steps.
Absolutely. Great thoughts, Jessi. And I can't tell you how many times people think their messages are gone, and they are months or years later proven that their understanding of how that works is in fact not the case. So first step is to be thoughtful and don't react, and think carefully about, who do I need to talk to? Should I do that in writing? Should I call someone on the phone? Should I walk down the hall? Not only what am I going to say, but how am I going to say it? Who am I going to engage here, and why? We'll talk about some of these variables a little bit more in a little while. I mean, the next step is, and this is sort of the other side of the coin of breathe, but don't breathe too much or too long if you've got a really imminent hot burning issue. What we don't want to do, if you happen to have a situation arise where there's an imminent safety issue or some other sort of emergency, don't let, in those situations, candidly, I would say, don't let perfection be the enemy of the good, in making sure you're doing whatever you can to get in the middle of stopping the imminence of whatever that particular situation is. But beyond that, and when you're thinking through assessing, okay, what do I do, and who do I talk to, and how do I proceed from here, that is going to matter. That's going to be driven very much by the nature of the issue that's been brought up, and we'll talk about those through our characters for today, and through really what are your policies and practices that you have, if any, on the record that sort of stake you out as to what you've promised to do in certain situations. If you have, for example, an open door policy or a complaint reporting and investigations policy, I'm going to tell you that your first step is to go read that and remind yourself of what you've sort of committed to do on behalf of the company if you get some sort of issue like from Miss Scarlett or any of these other characters to be brought to you. So Jessi, let's go to the next slide and let's just remind, so a few other steps here. So the second step is assess. The second and a half step is probably, not always, notify your counsel, particularly if you have in-house counsel, but in general, it's hard for us to think of a situation where doing this is a bad idea. That doesn't mean that every investigation needs a lawyer involved. It doesn't mean that every investigation needs a lawyer to lead or really direct the investigation. But it does mean that most of the time, having that threshold discussion about whether and to what extent a lawyer should be involved is really important. And the reason it's important, and we'll talk about this as we go forward. Let's think back, for example, to the example of Mr. Green. And we'll use these again as a proxy throughout our time today. Mr. Green, if you recall, made a complaint about unfair pay, being paid unfairly, not just him, but some of his coworkers too. That is inherently fraught with legal risk if he's right about that. And so thinking thoughtfully with a lawyer about what's being raised here, should we sort of cloak our investigation in the attorney-client privilege by having a lawyer direct or guide the investigation. Those are really important threshold considerations. And so at least taking a beat to have a threshold discussion with your lawyer is a good idea. Related to that, the third step is identifying the right people to move forward. You know, again, will lawyers be involved? Will they oversee? Will they interview and direct an investigation? Will they just sort of be kept apprised so they can give advice at the end or in the middle? Who else will you tell? Who will be a part? Who will sort of be brought into the fold? Who's going to know about this report and who's going to oversee the investigation? Doesn't mean a lawyer has to do it, but should a senior person do it? Should the supervisor of the complaining person be the overseer of the investigation? Should they not? Should it be HR? Should it be somebody else as the investigator to oversee? I mean, all these are sort of the threshold considerations. Any firewalls, meaning are there people that you need to affirmatively keep out of the loop? As a general proposition, most of the time, if an employee, whether they be a supervisor or anybody else, is implicated, meaning if they've been accused of some sort of wrongdoing, as a general matter, they should be kept out of the loop that the report exists until it's time to talk to them if you get to that point. And that's true whether they are a low-level employee or the most senior executive. And we have handled situations where both of those have been the case. And we've had to keep people who, frankly, are usually our frontline points of contact at an employer. We go around them on purpose because we've been told to, because that's what the situation calls for. And then finally, of course, as I mentioned before, privilege considerations are always sort of top of mind at this stage. When you're setting up the board to figure out who's going to be involved and who's not going to be involved and who's going to direct, thinking through how much of a role you need the attorney-client privilege to play in your work is a very important sort of overarching theme as you make those decisions.
And we'll talk more about the attorney-client privilege later because it has a lot of complexity when you're talking about investigating something.
So let's talk for just a second about these various characters we've got, Miss Scarlett and Mr. Green. If you recall, Miss Scarlett was accusing Colonel Mustard about some improper behavior, and we've got a few others here. And let's just use these as a proxy for talking, Jessi, about how we ought to think about triaging these various situations, right? So on the one hand, let's start with Miss Scarlett. Miss Scarlett's put something on social media complaining about a supervisor. That's Colonel Mustard, and mentions this company by name. I mean, let's think through for a second. Should Colonel Mustard even know about this report, this complaint? Jessi, what do you think about that?
Yeah, I mean, there are several issues that jump off the page when you're talking about Miss Scarlett and Colonel Mustard, right? One is she's named the company in a public forum. So immediately, you're flagging that there's something that's been broadcast to members of the public that are not part of the company that may be worth addressing. Depending on what the conduct is that she's complaining about, is it embezzlement? Is it harassment? Is it he's mean? That will be something to talk through with your team, with your counsel to figure out, okay, is this something that flags a legal issue, which we'll talk about in a minute? Is it an indication of employee dissatisfaction, which maybe doesn't trigger a legal issue, but may still be worth addressing? When you have someone who is accused of misconduct, there's always going to be a tightrope to walk in terms of how much you bring them in the fold as to what they have been accused of doing. You have to go in with an open mind, which we'll talk about in a moment. It may or may not be true. There's probably a lot more water under that bridge than you're aware of. And then as a baseline, I think you'll want to look at the social media post and figure out, can you independently verify that this is the post? Did someone else bring it to your attention? What are those circumstances? It's going to take a lot of analysis of what the complaint is, where it came from, and then thinking about the different steps you might want to take to look at the facts more closely, manage internal communications towards Miss Scarlett, depending on your policies, towards Colonel Mustard, towards members of the public. It's going to take strategizing in a couple of different directions. So again, it depends. but like comparing that to Professor Plum, who's making aggressive political derogatory posts, that could trigger different issues. Like, let's say he's making a post that violates your social media policy or your anti-harassment policy at work. That may or may not be something that blossoms into a full-blown investigation. If you can verify the contents of the post and you know for sure that they violate your workplace policy, that one may be a more straightforward issue of just taking the appropriate disciplinary action for violation of a workplace policy.
And so that's a great contrast. And we've got considerations of a social media policy. They're definitely, and referencing your policies when you talk about Professor Plum and perhaps Ms. Scarlett and Colonel Mustard, you don't really have any policies you need to think about. By contrast, when you think about Mr. Green's complaint about unfair pay. Unfair pay is not really a policy violation. It's an allegation of a legal violation. So we're not going to the employee handbook and looking for, if we've got some violation we need to look into. We know what the issue is. So we're not trying to decide the relevance of policies. We're trying to decide what laws are implicated, which we're going to get to in just a minute. The last thing I would just call out here as we walk through our characters, Mr. Body here on the right, who's made an accusation about the most senior leadership in the company, treating folks with discriminatory fashion. Now we're thinking really hard about, well, gosh, all the people I would use, this probably is a big deal. Who knows if it's true or not, but just the allegation is consequential. But we're going to have to fight our natural instincts of running this up the proverbial food chain like we might do other risks or things that are brought to our attention, because the very people who are implicated by this allegation are the very people we would naturally go to make them aware of it and develop an action plan. So Mr. Body is unique here because unlike some of these others who sort of don't raise the issue of cabining off certainly senior folks, that's exactly the core threshold issue that we've got to think about with Mr. Body. But all of that relates to and is imbued with the sort of legal landscape and the legal considerations we've got to think through that are implicated in each of these. So Jessi, why don't you take us through some of the most relevant laws that we think are triggered both here and generally with issues like this?
Sure. So look, we're lawyers giving this presentation. Of course, we're going to touch on the laws. And a lot of you will be familiar with some of this alphabet soup that I'm going to run through. They basically fall into two different categories. It's either a law that gives some kind of protected right, some kind of protection. So the Fair Labor Standards Act, which governs minimum wage and overtime, medical issues under the ADA or the FMLA. The Speak Out Act is a fairly new law at the federal level that restricts non-disclosure agreements in advance of or enforcing an NDA with regard to a harassment or assault allegation in the workplace. I want to focus on two of these laws in particular, and that's the National Labor Relations Act and Retaliation, which is a legal issue that can apply to any of these laws. And that's for two reasons. One, as Bryan forecasted in the beginning of this presentation, those are areas where we've seen some pretty significant developments in the employment law space in particular. And the second is these seem to be areas of enforcement priority at the federal government level in particular right now. So these are the two kind of hot button issues that if you take nothing away from the legal section of this presentation, these are things that are worth having in the back of your mind next time you have an employee raise a concern or act out.
And Jessi, I would just want to add as to these particular legal landscape points you've made. On the bottom on retaliation concerns, I suspect that most of you out there, and hopefully all of you with any employee handbook worth its salt, have some sort of non-retaliation policy. So regardless of what legal protections there are for retaliation, I'm confident that most, if not all of you, have already made a promise to your employees about not retaliating for raising whatever concern they raise. So that's separate and apart from legal issues. You've got to think about your process in a way that is mindful of what that likely policy says to you.
Yeah, that's a good point. So talking about the NLRA really briefly, this is a law that if you've attended prior presentations of ours, we touch on pretty regularly. The NLRA, if you go back to its origins in 1935, it was enacted to protect employee rights and encourage collective bargaining. So back in the days of, factory picket lines and things like that. The NLRB, the National Labor Relations Board, is the government agency that enforces the NLRA. So they are both the enforcement agency and they are kind of the judge, so to speak, if someone files a charge alleging a violation of the NLRA. It's important to recognize that the rights protected by the NLRA and NLRB apply to both workplaces with unions and workplaces without. If you employ people, you have a legal obligation not to infringe on their ability to engage in concerted activity. And what that means in 2023 is that employees have a protected right to raise concerns in the workplace about their working conditions and the working conditions of their colleagues. There are some exceptions, but as I'll get into in a minute, this is really, as it's currently being enforced, a pretty narrow exception. A couple of areas where we've seen significant developments that I want to flag, both because they're a departure from what we've been seeing and because in some ways they're kind of counterintuitive if you have been in the business of managing employees for a while. The first is electronic monitoring. We've seen some enforcement guidance from the General Counsel at the NLRB that suggests if you engage in any kind of monitoring in your workplace, that could be cameras in your lobby, that could be dashboard cams in company vehicles, that could be anything where you're using a webcam or software to track employees working at home. There is a risk that by using that technology, you will be perceived as discouraging employees from engaging in that concerted activity. So again, if you're using some kind of surveillance, just be aware that that's out there. With regard to severance agreements and separation packages, this is something that will come up as we walk through those fact patterns we introduced in the beginning. The current NLRB position is that you cannot have an employee sign an agreement that has a non-disparagement provision towards the company or that restricts the confidentiality of the terms of the separation. That is a big change, and it is it's going to have some trickle-down effects in how people separate employees from employment. So it is worth being aware. I will also note, we saw a news alert come across our desks this morning that a company is being sued because their CEO said something that's considered disparaging against an employee who had entered into a non-disparagement agreement with the company. So this is something to be mindful of in both directions. NLRA, NLRB authority is also evolving on the standard for protected activity. So I'll talk about that more in a minute, but the bar is much lower for what gets that protection. And then same for this abusive behavior standard. Historically, it was like you could engage in protected activity, but if you were cursing, if you were attacking somebody in an abusive way, it was not necessarily protected. And we're seeing changes in that landscape as well. So what is protected workplace activity? It's broad, really broad. It's any of the complaints that we used in the examples. It's seeking or using an accommodation for a medical or religious reason. It's talking about rates of pay with coworkers or raising concerns about your rate of pay. Making any kind of complaint or charge in good faith about harassment by another employee, or participating in an investigation. So that's important to keep in mind as we talk about structuring the fact-finding phase of the misbehavior. Anyone who's engaged in that investigation, whether as a reporter or as a witness, has some level of protection under the current law, and it'll be important to be on your guard there. And the same for retaliation. When we say retaliation, we don't just mean getting them fired. The EEOC says it can be that they are treated differently, they are harassed. There's some guidance I've seen out there that's like, if you have a workplace lunch and this person stops getting invited to the workplace lunch, that might be retaliation. So the standard is, essentially, is this conduct that would arguably discourage someone from raising the concern, from engaging in the activity, taking that medical leave? So as the employer, things you want to be watching for are timing and circumstances that may indicate retaliation. If you have someone who has a history of performance issues and you take a disciplinary action about those past performance issues right after they've made this complaint about harassment, you're setting yourself up for a retaliation claim. So it's really important to think through timing. And in the particular example I just gave, this is why you'll often hear us encourage employers to document and address performance issues on an ongoing basis so that you have something to relate back to if there's an intervening factor here. And then, as Bryan mentioned, you're also going to want to look at your workplace policies. So again, if we work with you on a regular basis, you'll hear us say we think it's important to have these policies to indicate as a workplace that you take these issues seriously. And that's great. And then when something happens, you got to follow your policy. And that could be in a couple places. That could be in your workplace handbook. It could be in your board of director policies. Like sometimes we'll see a whistleblower policy that is run through the board of directors instead of internally at the workplace. So as the person or department kind of spearheading this fact-finding situation, you're going to want to look for things like, do you have a whistleblower policy? Do you have document retention policies? Do you need to do anything to stop automated deletion of things like emails that might be relevant? Do you have a progressive discipline policy? If you have something that says we follow these 4 steps, you better follow those 4 steps if it turns out that discipline is warranted. Certainly policies against harassment and discrimination could be relevant. A lot of employers have open door policies. So, we encourage you to come forward with concerns. Okay, well, that means when someone raises the concern, you got to follow through with that policy. Same with the policy against retaliation that Bryan mentioned earlier. And then depending on the nature of the complaint, if it's something about wages or working conditions or taking leave, you're going to want to look at what your policies say about how someone takes leave. What are the protected rights to PTO or medical leave or something like that. And then the last thing I'll flag is looking at confidentiality and trade secret information. If the thing that gets brought to your attention somehow implicates secrecy around sensitive commercial information, it's going to be relevant either in your fact-finding phase or in the moment that you take action for you to know what your policies say about how you manage those kinds of things. So looking at the potential legal issues that you might see in these examples we used in the beginning, I've already talked about some of them, but Bryan, let's start with Miss Scarlett and Colonel Mustard. What are some laws you think might be implicated with her social media complaint about Colonel Mustard?
Yeah, so we've got a couple of things that are top of mind here for me. One is the complaint, as we understand it, or the information we have, is that there's bad behavior by the supervisor. We don't know if that's rudeness. We don't know if that's rises to the level of perhaps some sort of harassment. So we might have some Title VII, some discrimination type laws that are implicated, but we probably also have some NLRA issues here. If you're talking, she is talking about the terms and conditions of her employment. She's talking about how she's treated in the workplace. And so one thing that jumps off the page for me there is she perhaps has she done enough to where we've got to be very mindful that even though we don't like that she took her concerns outside the company to social media as opposed to raising it internally, we need to be thoughtful about whether any sort of reaction or discipline for taking those sort of internal issues and expressing them to the world, has she exercised her Section 7 or her NLRA rights there?
Mm-hmm. Yeah.
Turning to, how about at the same time, let's talk about Mr. Green, Jessi. What do you think about Mr. Green?
Yeah, immediately there's a question about if he's complaining about unfair pay. Is he saying, hey, we're not getting paid overtime? Is he saying, hey, you're forcing me to log off, clock out, and then continue working? If that's the case, then you've got potentially some bigger issues because you could be violating state and federal wage law. That could turn into a big old issue with the Department of Labor. And that's going to be something that you're certainly going to want to engage counsel on sooner rather than later. If his complaint is more like, man, I really wish we were getting paid more. I feel like for an honest day's work, I should be making twice what I'm making. Then you're probably touching more on Section 7 rights under the NLRA. So you're going to want to think about whether he's doing something that that amounts to engaging with his colleagues to negotiate a raise, or if he's just out there, being a squeaky wheel, that might mean something altogether different. But those are the two issues that come to mind for his situation. Now, I want to skip over Professor Plum because I think in some ways his situation is similar to Miss Scarlett's, where there's this question of what is he posting about? Does he violate workplace policies? Again, as I mentioned earlier, does he violate harassment policies and those kinds of things? I want to talk about the accusations around the leadership team. Bryan, what do you see there as potential legal issues that an employer should be mindful of?
Well, the one that really comes most to mind for me is actually sort of secondary to whatever the threshold legal claims are or legal issues that have been raised, and that is retaliation. I think there's a natural concern that if there's an accusation made about particularly senior or most senior people, that frankly, that takes a lot of courage on behalf of an employee if they have a genuine complaint. And they're going to be afraid about retaliation. And I'm going to be thinking very carefully about how do we make sure that whatever this turns into, whether it's a claim that is this known as a discrimination claim or under Title VII or some other applicable discrimination law, what are we doing to ensure that the process that we put in place protects against the retaliation charge? Obviously, the discrimination laws are implicated, but I think the biggest legal risk is likely to be retaliation. And the other thing I'll say is, and this applies to Mr. Body here, and probably Miss Scarlett too, is it's not really a legal issue so much as it is a what I would call a marketplace or a brand risk. I mean, you've got Miss Scarlett out there mentioning your company's name and complaining about something bad that's happened in the workplace. And then with Mr. Body, you've got allegations against the most senior people that were those to become public. That could really have some actual economic and brand harm to the organization. And so I'm thinking about any policies that you have that relate to, as Jessi mentioned, perhaps confidentiality, perhaps a social media policy that are designed to really address and try to manage that sort of perception risk or brand risk that can come with people sort of not delineating between the work being inside and outside the workplace.
Yeah. So then if we assume that you've learned of the incident, you've done an initial analysis, you've talked with your legal counsel, and they've said, okay, here are some things that I think we ought to be aware of. Next is diving in to figure out, what do we know about what happened? What can we find? Where should we look? Who should we talk to? And the formality is going to depend on the issue. Using that Professor Plum example where we have a social media post where he's saying something that violates probably the law and your workplace policy, there's not a whole lot of investigating that needs to happen there, most likely. But with some of these other situations, you could be pulling on a thread in a sweater. And you see this happening in the news, not uncommonly, or you may have experienced it in your own workplace. And so thinking about what your fact finding might look like, does it involve interviews? If so, is it interviews of the complaining employee, the reporting employee, and the person who's accused, or is it something more than that? Is there an accusation that somehow brings in a whole department at your workplace? And if so, do you want to talk to all of them or just some of them? Do you want to look through documents? Do you want to look through emails and Slack messages? Something, I'll jump to the bottom of the slide really quickly. Something that's very important as you're thinking about your process is if your process is designed to reach a predetermined outcome, it's not going to reflect well on the company, and it's probably not going to be worth your time. If you're intentionally saying, hey, we think this guy has been sending harassing emails, so we're not going to look at emails. We're going to look over here at, this interview instead. It's not going to achieve it's not going to achieve its purpose, and it's not going to make the company look good, and it's not going to help you defend a possible claim. So thinking about the scale of that review, again, a document retention thing, like if you have your email automatically deleting every 60 days, really important to put things like that on pause as soon as you hear about something that might be breaking the law or violating a policy. Bryan mentioned earlier this potential need for firewalls, which would be precautions you take to make sure documents and information relevant to the incident or the investigation are kept apart from certain people. Handling with discretion. A lot of times when you have someone who's come forward with a concern, they want assurance that the conduct can be kept private. And it's typically not something that we can promise. We can, however, take steps to handle things with discretion so that there's minimal workplace gossip, so that conversations are direct and to the point. Whatever we can do to prevent something from becoming a source of workplace gossip is going to be helpful here. Thinking about both internal and external communications, which we'll touch on in a few minutes. Are there, as Bryan pointed out, marketplace communications that we need to be thinking about? We certainly need to be thinking about how are we going to be communicating with the person who raised this issue, with the Miss Scarlett who posted on social media about her boss's bad behavior. What are we going to be telling her about what we're doing, how we're doing it, without sharing personnel information that she's not entitled to have? And then privilege, as Bryan mentioned earlier as well, when you have attorneys involved, generally speaking, there is an attorney-client privilege over what we share, and that's so that you can speak frankly with us and we can speak frankly with you. When an attorney is involved in an investigation, there may be privilege or there may not be. And so it'll be important to talk with your counsel about how much it makes sense for them to be involved versus behind the scenes advising. There may be times you want to shoot your shot and have an attorney doing the investigation to try to maximize the chance that that information is privileged. And there may be times you want them to take a back seat. When something is privileged, another person cannot get at that information in a lawsuit. So if you and I have a conversation and I say, you've got legal risk here, because this violated a law, we want the privilege to apply to that communication so that when somebody sues the company down the road, they're not able to say, oh, look, even their company lawyer thought there was a risk here. So that's why privilege is something that's very important to handle with caution in an investigation session in particular. And then again, as I mentioned a minute ago, you don't want to start the process with a predetermined outcome. Bryan, I'm cognizant of time here. I want to make sure we get everybody done in an hour. Do you want to pick one of these that you're excited to talk about the process for?
Sure. So one that really comes to mind here in terms of process, well, there's really two, but I'll start with the Mr. Body with senior level accusations. That's a situation in which designing an effective process is really critical out of the gate. It's likely that every person to whom you might naturally sort of report to about the status of what's going on might be ineligible to be reported to because they're implicated. And so, do we have to go to the governing board of the organization or create even a special committee of that board to oversee what's going on? I think that's a very important process component. The other thing I'll say as a matter of process is, and Jessi touched on this when talking about privilege, and documentation, is sometimes there are times when you want a lawyer to guide the investigation and you want to tell the lawyer not to give you their advice in writing. You want to do everything and all the work with Zooms and phone calls. And the reason is you don't ever want to be in a position of having created a document that has, frankly, perhaps lays out all the things that the company has done or its senior executives have done that are unlawful. You definitely want to learn about that, but thinking 5 moves ahead, you don't want to be in a position where you've got to make a decision when you're in litigation 2 years later about whether that document should be withheld on privilege grounds, whether you should produce it. And so the best approach can be to sidestep and be thoughtful about what you're writing down and what you're not. I know it can be counterintuitive, but we've definitely had that happen actually fairly recently, a couple of matters. Jessi, I think you're right about time, so let's make sure we're continuing to go forward.
Yeah.
I think you're going to
talk
about communication strategy, right?
Mm-hmm. Yep. So we've touched on some of this already, but when you're thinking about what your process is going to look like, that's going to be hand in hand with what's your communication strategy. And that means, what is your strategy for while you're looking into things? What are you telling people that you're talking to or interviewing about the thing you're concerned about? And then where are places that you need to plan for a communication either after you're done with your investigation or kind of while the investigation is happening, if you're worried about customers or stakeholders or members of the public? So first step, obviously, is identifying that possible audience. Certainly the employee who brought the issue to your attention, perhaps coworkers, perhaps people that have seen that social media post. It occasionally maybe a government agency, if they've somehow already been brought into the loop by an employee who raised a concern. Thinking about the formality of the communication. Is it just some talking points that you're using for these conversations? Is it a press release? Is it working with a PR agency to be prepared for goodness knows what going into the public space? Thinking again about the evidentiary issue. Are you going to, you want to be mindful about what you're creating and the fact that it could someday be an exhibit to something that's filed in a court. And so I think that with regard to the social media posts in particular, there's clearly an external component here. But looking at the leadership team example with Mr. Body and thinking about things you've seen in the news recently, right? Some companies, like I'm thinking of in the Me Too movement, where there was a supervisor who engaged in conduct for a long time, was not challenged. And then when it came to light, it turned out that there were things that had been happening for an extensive amount of time that the company had not reeled in. If you're in a situation like that in particular, I think that's a PR firm worthy moment, talking with your attorney to figure out the best way to get that teed up. Internally, thinking about, again, what are you sharing and with whom? What will you say at the conclusion of the investigation? What will you communicate about your findings? Is it as simple as reiterating that you have that open door policy, that you do not condone discrimination? Is it sharing more information than that? Again, it's really going to depend on what the concern is, who might know, and then thinking through, you don't want to kick up more dust than necessary, but you certainly want to address concerns if you think employees are talking about it and worried about something. And then we get to the action plan. So you've done your investigation, you've more or less concluded, you have a pretty good grasp on what happened, and you're trying to figure out what's next. Bryan, what do you think?
So we began it with the end in mind, right? And now we're at the end. So what are we going to do with all this? So depending on what you find, I do think it's, generally speaking, a checkpoint with your counsel is a great idea. What do we make of this? Is this something? Is this a violation? Does this need a cure? Let me tell my lawyer what we've found, or maybe the lawyer's involved. But I think contextualizing what you've learned to figure out the severity of the situation is quite important. You might actually discover during that process that there's a stone you didn't turn over that you need to turn over. You didn't talk to somebody you should have, or you need to follow up on something. And so it's nice to sort of do a final synthesis in the process. And then in terms of what the fix is, of course, that's going to depend on the situation, but maybe, for example, Professor Plum, who was talking and making derogatory comments, sort of inappropriate, that may not align with your corporate values out on the internet, on social media, maybe you may not have any policy for that. There's probably no agreement or no document that governs his employment or behavior other than your general policies. And that's sort of a values issue, not a policy issue. So do you want to create one? Is there a way to do that? Is it just a coaching situation? So
it might be a termination situation too.
Might be a termination, might be, again, to your progressive discipline point earlier, Jessi, it might be a step one in the progressive discipline if you've got that. And so, matching the punishment to the crime, so to speak, to stay with the clue analogy here, is certainly core at this stage. And then talking about how to communicate. Who are you going to communicate this outcome to? At a minimum, it's almost always a good idea to communicate to the reporting employee, not to tell them what happened, because if you're going to take disciplinary action against the implicated person or persons, that's a confidentiality issue in and of itself. You don't tell the reporter what's happened, but what we typically advise is you tell the reporter, thank you, we're so glad you brought this to our attention, we've looked into it, we've taken appropriate action. That way the reporter knows that he or she was heard, right? Because if they're not heard, and there's social media out there, if they don't think they're being heard internally, they may go tell the world. And so communicating back with them is a great idea. And then creating some sort of record or document that shows that you analyze the situation. Now, you just heard me say a few minutes ago, sometimes you don't want to write things down. And this is a fine line that depends on the situation. And I think in the senior employees issue with Mr. Body, that probably leans towards not writing a lot. But by contrast, the Professor Plum situation, Mr. Green, who was the improper pay situation, that probably definitely warrants writing things down. And the reason is, if you're accused of not paying someone properly under the relevant pay laws, if and you're wrong about that, you're in the wrong and you don't change your process, you can get accused later of, again, for violating pay laws. And if you're told a second time and you haven't fixed it, that turns into what we call a willful violation. Your fines can be bigger, your fees can be bigger. And so demonstrating that you weren't willfully violating the law because you took a hard look at the question, sometimes it's really important. It just depends on the law that's implicated. So like everything here, these 4 different situations are going to dictate different outcomes.
Going to the outcome communication issue, Bryan, I want to think about like Miss Scarlett posting on social media about Colonel Mustard. I think that's an example that we see often where an employee is complaining about a supervisor or another employee. I think the temptation can be to go back to Miss Scarlett at the end and say, well, we're going to fire Colonel Mustard. We fired him. Thanks for giving us a heads up. And that walks you right into personnel privacy issues. Yeah. So to Bryan's point, that's the kind of moment where you would go back to Miss Scarlett and say, we appreciate you raising the concern. We hope you know that as a company, we have these policies for a reason. Please feel free to bring them to our attention in the future. And we just want to let you know we've looked into it and we've taken appropriate action. She's been validated. She's heard and seen that the company takes harassment, and I'm assuming it's harassment, takes bad behavior seriously. And she's been validated that when she raises concerns, appropriate action is taken.
So some other variables just to briefly consider when you're thinking about how to message your sort of your closeout and your sort of outcomes. You do want to be thoughtful about who you're talking to. Sometimes it makes sense to let people know that whom you've interviewed but weren't directly implicated, that you've concluded the work, because they might be worried that, wow, I was getting some weird questions there. I wonder, am I going to be in trouble? What's going on? I'm worried. And it sort of creates a needless distraction that, absent sort of bringing finality to it, can be unproductive. Thinking carefully about how to message the what happened, typically less is more. You don't really, to the privacy and other issues we've already talked about, you don't really want to tell anybody more than must know what the outcome was and how you got there, because you're just sort of acknowledging perhaps bad acts and you're sharing confidential information. And then finally, on the third point, don't pass blame to your attorney. We don't at all suggest that we're forever blameless. But what we do mean there is, if you go to someone and say you have to terminate them or you have to take an adverse action, what you don't want to do is say, well, my attorney said we have to do this because, or my attorney instructed us that what needs to happen next is blank. Because what you've just done is waive the privilege about all the advice you got and how you got to the outcome. And so typically attorneys are sort of behind the curtain, helping advise, helping oversee, helping observe and give counsel, but we're not the frontline communicators, because exactly this issue of the protecting the privilege.
So we're fine being the bad guys. We know that we are. Sometimes we have to help you guys make bad decisions, hard decisions, good, hard decisions. But as soon as you say, our attorney said we have to fire you, you got other issues. We've got just over 5 minutes left. I don't know if anyone has a question that you'd like to drop in the box. Otherwise, Bryan and I will talk a little bit more about the examples that we started the presentation with.
All right, so let's talk for a minute, and we'll keep an eye on in case any questions come in. Let's talk about Ms. Starrett for a minute. Jessi, the process we would have gone through there, some sort of, I know we've seen situations like this, some outcomes that we've seen. What are your thoughts on that?
Yeah. So the first thing that actually came to mind for me with this example is, if you have let's say for the sake of argument that this bad behavior is harassment or discrimination. If you have a policy in your handbook that says, if you experience harassment and discrimination in the workplace, this is what you should do. That policy doesn't say you should go post it on social media. So the first thing that I would encourage a company to think about in this situation is, what do we need to do where is the disconnect between our policy and what Ms. Scarlett did? Is this an opportunity for us to more clearly communicate our policy? Do we need to do a workplace training on what our policies and protocols are? Is there a reason that Ms. Scarlett took to social media instead of coming to one of these folks in HR? That's not to say that Ms. Scarlett did something wrong or that we would penalize her for it, but we would want to find a way to encourage her and other employees in the future to bring them to someone internally so we can address them, right? Going to social media doesn't really give you that opportunity. The investigation would depend again on what the specific allegation is, but thinking about talking with Ms. Scarlett, most likely talking with Colonel Mustard. If Ms. Scarlett names other employees who have reported to Colonel Mustard in the past and had a similar experience, that could be worth considering. Thinking about, again, documents that they might have exchanged. Is it an email, text message situation? A lot of employees use personal cell phones for work purposes these days. So thinking about whether there might be text messages on personal cell phones that she might be willing to let us review as part of our review. And then thinking about at the end of that review, if we're reasonably sure that we know what happened, what can we do going forward to avoid not just the public reporting next time, but avoid the actual conduct? Again, is that training for Colonel Mustard specifically? Is that training for supervisors? Is it a refresher for everybody on what that handbook says? Is the policy maybe not as clear as it could be? It's a learning opportunity for the company at the end of the day.
So mindful of time again, let's just talk about one more. Let's talk about Mr. Green, because I think it does implicate a few unique decisions here, because I'm going to assume for a second that Mr. Green was at least partially correct in his complaint, that there was some sort of incorrect pay, or he calls it unfair, but maybe there's a question about whether he's being properly treated on the exempt versus non-exempt status and the overtime or not. We've got a hard decision to make if we think he's right, because we've got to decide, this is not a policy question, it's a remedy question. What are we going to do to fix this? Are we just going to fix it for Mr. Green? Are we going to look at all other people similarly situated to Mr. Green and fix it for them? Are we going to cast a wider net and do a larger audit to see if we have other issues and other positions? And if we are going to fix this issue, are we only going to fix it going forward? Or are we going to fix it looking backwards for some period of time? And how far back? And all of those decisions are really fraught with careful communication with these employees about what we're doing and why. They're also fraught with considerations that if we don't sort of make the employees whole, so to speak, for whatever period of time they were not paid correctly, we are exposing ourselves to more legal risk, because we've just done an analysis, concluded we were violating the law, but we haven't righted the whole ship. And so now we may have risk of a willful violation going forward. So this is really, there's going to be lots of discussion about marrying up legal risk with outcome decision-making here. And that's probably going to include financial considerations as well. So those are just, sorry, go ahead, Jessi.
No, I was agreeing with you.
Yes, let's make sure we give the folks, and we will hang out here for a few minutes in case you have questions about anything we've talked about.